Okay, I'm doing my oral presentation on Rogers v. Richmond. In November of 1953, a woman named Dorothy Kennedy was shot and killed in the liquor store that she owned during a robbery. 6 weeks later, police were looking for Harold Rogers in connection with a separate robbery that occurred at a hotel. They found Rogers in his vehicle and in the possession of a .38 caliber rifle. Soon after, the police learned that a .38 caliber revolver had been reported stolen by Rogers' nephew on the day of the murder of Dorothy Kennedy. Ballistics testing matched the gun to the ballistics that had killed her. Rogers was transported without a court order from the jail to a state attorney's office, where he was questioned throughout the afternoon and evening about the murder. During the questioning, a police officer pretended to call other officers with directions to take Rogers' wife into custody and to have their foster kids moved to a detention facility. This action caused Rogers to confess to the crime because he didn't want his wife, who suffered from arthritis, to be taken into custody. Later, he confessed a second time when being questioned by the coroner. Prior to trial, Rogers' attorney tried to get the confession thrown out so that it would not be heard by the jury. The test applied by the trial court to determine the voluntariness of the confession was whether or not the conduct of the state's law enforcement officials had induced Rogers to falsely confess that he had committed the crime. The confession was found voluntary, and it was used in the trial. Rogers was found guilty, and he was sentenced to death. I've made a little slide here to kind of show the appeals process that Rogers went through. First, he appealed at the Supreme Court of Errors and argued that his confession was involuntary and should have been excluded from the trial. He claimed that the jailers had refused to allow his attorney into the jail and that he only confessed to save his wife and children from being harassed by the police and possibly removed from their home. He also claimed that his second confession to the coroner was but a product of the first confession. The Supreme Court of Errors, in using the voluntariness test, found that the confessions were voluntary and ruled against Rogers. Rogers then filed a writ of habeas corpus on the grounds that since the confession was secured under circumstances rendering it constitutionally inadmissible, he was denied the due process right of law under the 14th Amendment. The U.S. District Court for the District of Connecticut found that the confessions were involuntary and set aside his conviction. The state appealed, and the U.S. Court of Appeals for the Second Circuit vacated the district court's judgment because the district judge should have requested the entire record before reaching his decision. They claimed that the district judge did not have all of the information. The case was remanded back to the district court with instructions that the judge, upon reviewing the entire record, had to find vital flaws and unusual circumstances in order for him to vacate the conviction. Rogers appealed his case to the Supreme Court, who denied cert. However, the Supreme Court did write a per curiam opinion which basically agreed with the Court of Appeals decision. A second writ of habeas was filed, and the district court judge found that due to the instructions given by the Court of Appeals and the Supreme Court, and after reviewing the record in its entirety, he could not establish vital flaws and unusual circumstances and was therefore unable to grant the writ. It was dismissed. Rogers appealed again to the Court of Appeals for the Second Circuit, which rejected his petition. This finally brings the case to its appeal at the Supreme Court. Rogers' cert petition was granted, and oral arguments were held on November 7th and 8th of 1960. And I've got a little graphic here of the makeup of the Supreme Court that decided his opinion. The question presented to the Supreme Court was essentially whether or not the voluntariness test had been applied correctly at trial. The Supreme Court decision was issued on March 20th, 1961. In a 7-2 decision, they found in favor of Rogers. The majority opinion was written by Justice Felix Frankfurter. In his opinion, Frankfurter held that the trial court and the Supreme Court of Errors failed to apply the correct standard in assessing the voluntariness of the confessions as set forth by the Due Process Clause of the 14th Amendment. He wrote, "Convictions following the admission into evidence of confessions which are voluntary, i.e. the product of coercion, either physically or psychologically, cannot stand. This is so not because such confessions are unlikely to be true, but because the methods used to extract them offend an underlying principle in the enforcement of our criminal law, that ours is an accusatorial and not an inquisitorial system." What Frankfurt is basically saying is that the United States is a common law country, which means that we have an adversarial system. The prosecution and defense compete against each other, and the judge serves as a referee to ensure the fairness of the accused and that the legal rules are followed. The inquisitorial system is based more on a pretrial investigations and interrogations. The inquisitorial process can be described as an official inquiry to get to the truth, whereas the adversarial system uses a competitive process between prosecution and defense to determine the facts. Frankfurter went on to say that while the trial judge ruled that Rogers' confessions were freely and voluntarily made, that he had reached that conclusion on the basis of considerations that undermined its validity. When the officers had their pretend conversation in Rogers' presence that they were going to take his wife into custody, he confessed so that they would leave her alone. That you don't necessarily have to beat someone in order for a confession to be extracted from them. Frankfurter pointed out that both the trial court and the Supreme Court of Errors had incorrectly concluded that the probable reality of a confession is a circumstance of weight in determining its voluntariness. In other words, the lower court were basically saying that as long as there was some possible truthfulness to the confession, it's voluntary. The Supreme Court remanded the case back to the Court of Appeals for a new trial to take place. Rogers ended up taking a plea to a reduced charge of second-degree murder and a life sentence. Justice Stewart authored a dissenting opinion in which he said he agreed with the majority that the state courts gave some weight to the probable truth of the confession in determining that they were voluntary. He didn't agree that Rogers is entitled to release merely because of the state court's failure to properly verbalize the correct 14th Amendment test of admissibility. In an article published in 1962 in the Montana Law Review, Richard Andriolo, in exploring the Rogers v. Richmond case, said that in the Supreme Court opinion, they were stating that even if a confession is clearly reliable, it is inadmissible if the will of the defendant has been overcome and his capacity for self-determination critically impaired. Andriolo explains that the consideration of the element of reliability is not allowed because it cannot be determined what weight the trial judge placed on that element. If the confession is clearly reliable, the judge may interpret or relate facts in a way as to emphasize those facts which tend to show the confession was voluntary and to de-emphasize the facts which tend to show that the confession was involuntary. He claims that if the judge feels that the confession is unreliable, his emphasis may just be the opposite. In another article that was published this winter in the Northwestern University Journal of Criminal Law and Criminology, author Dean Strang explores how the courts have applied the Rogers test to bar considerations of both accuracy and inaccuracy of a confession in deciding voluntariness and how they have been wrong in that application. Strang says that the Rogers decision stated that courts may not consider the accuracy or truthfulness of a confession in deciding its voluntariness, but that many courts have assumed or ruled on the opposite, that the inaccuracy of a confession does bear on voluntariness. They repeatedly have considered whether the police tactics might have produced a false confession, not whether those tactics produced involuntary ones. Strang goes on to say that the state court decision was based on an implied assumption that Rogers had confessed truthfully and accurately. Rogers had his nephew's gun at the time of his arrest. The nephew had reported it stolen before the robbery and murder, and ballistics testing linked the fatal bullets to the gun in Rogers' possession. The assumption that Rogers, in fact, was the murderer had support. Now I'm going to show a quick video that kind of explains the voluntariness.
Anytime a suspect is in custody and being interrogated, the officers should read to him his Miranda rights. I have a couple of videos on Miranda, and I encourage you to review those. But essentially, the officers will tell the person that they have a right to remain silent, anything they say can be used against them in the court of law, and that they have a right to have an attorney present during the interrogation. But let's say in this example, the suspect gives up or waives his Miranda rights. So he tells the officers he's okay speaking to them. Does that mean that the statements that he makes will automatically be admissible in court? Even if the suspect voluntarily, knowingly, and intelligently waived his Miranda, that does not mean that the statements that he has made afterwards will automatically come in. They might still not pass the voluntariness requirement under the due process. And let me explain what that means. Before the statements come in, courts will conduct a two-step analysis. First, the court will look if there's any coercive behavior by the police. And then they move on and see if that coercive behavior has overcome the suspect's will. When we focus on the first step, we question whether the police used force or psychological ploys that are so coercive that they make the statements involuntary, or, and even more importantly, unreliable. When we look at the second step that deals with free will, we look at the particular suspect who is being questioned and his traits, including age and mental disabilities. Did the officer's conduct overcome that person's free will easier because of those traits? Now, something to remember. Under the totality of circumstances, the courts will not focus on if the defendant or the suspect told the officers the truth. In fact, the question here is not whether the suspect is guilty or innocent. Some questions in our Constitution go beyond that. And under the voluntariness requirement of the due process, the question is, did the method of extracting a confession violate our Constitution and the principles under which our criminal justice system is structured? The prohibition on the coercion of the confessions also turns on the deep-rooted belief that the officers and the police must obey the law while enforcing the law. And if you enjoyed this video, please click like, subscribe, hit that bell.
Okay, it's kind of a funny video. So in conclusion, Strang wrote that Rogers v. Richmond stands as a solid support for the propositions that courts must not consider accuracy and probable accuracy of a confession as any proof of its voluntariness. The confession may be perfectly truthful and accurate, but if it was involuntary, its truth and accuracy will not save its admission. And indeed, accuracy does not matter to the due process question. This concludes my presentation.